Hi, everybody, and welcome back. We are going to cover Chapter 8 in this lecture, which focuses on the courtroom working group, and the criminal trial. So now that we've covered Chapter 7 and we've looked at that hierarchy of the court system and how it functions, I want you to know about the people who are actually working in the courtroom, what they do, what responsibilities they have, what power they have, etc. So one of the things that I want you to understand are some of the nuts and bolts. And again, this is going to be dependent on the state in which you live. There are different processes. But let's start with the grand jury. This is something you probably heard about in the news, but you probably have never, taken the time to wonder, how is that different from any other jury? How is that different from any other courtroom? Not every state uses a grand jury, but many do. And for those who do, what ends up happening is an arrest is made by law enforcement. Law enforcement will gather evidence. They will submit it to the district attorney. The district attorney will present it to the grand jury, which is a group of citizens just like any other jury. And basically what the grand jury is trying to determine is, based on what you guys have gathered in terms of evidence, does this warrant a trial where we investigate this in a much more specific fashion? Okay, so the district attorney is going to say, hey, this is what we found. We think this person over here, we think this is who did it based on this evidence. They call it a case of prima facie evidence. And what that means, prima facie, means it looks like. Prima facie is just another way of saying it looks like. It looks like, based on the evidence we've gathered, that it's this person. Grand jury, do you agree or do you disagree? Because if you agree that there's a prima facie case of evidence here, then you're going to indict. And what that means is, when a grand jury indicts, what that says is, hey, we need to have a full-blown trial. Right? There's enough evidence here that it's indicative that this person could be the responsible party. So we need to do a much more thorough examination with a formal case, right? They're basically saying, among this evidence, there's more than just a little bit of smoke, right? There's a tiny little flame of fire, and we want to see if that little flame is actually the entirety of the fire. And we can't do that without looking into a formal trial where we really investigate the evidence. We try the person in front of a jury, and we really weigh the evidence and let a jury decide. So that's what a grand jury is. States that do not make use of a grand jury use something called a preliminary hearing. And this is where the judge will review the accusations and the evidence up to that point. So rather than a grand jury of peers determining whether or not to indict, a judge is presented with all of that evidence, and he or she determines whether or not there's probable cause to pursue a formal trial. If they think there is, then we have a formal trial. Right? Preliminary hearings tend to lean towards protecting the accused, right? Whereas grand juries are made up of random people. And this is something that most lay people don't understand. But juries are very emotional, be it a grand jury or a formal jury in a formal case. It's very emotional. They're human beings. They get swayed by the emotion of what's going on, what happened to the victim, what are the circumstances. And sometimes in that process, the facts and the law get lost, and it becomes more about theater and a story and finding what we think is the right ending to that story, rather than looking at the facts and the limitations of the law. This is why a preliminary judge is more likely to be conservative about indicting and look more towards an individual's civil liberties than will a grand jury. So let's talk about pretrial detention and bail. So if you have been arrested and if you are indicted, be it in a preliminary hearing or at a grand jury, you will be going to trial. There's a couple of things that can happen here. Your bail will be set. The judge will take a look at the accused offense and say, hey, you're accused of murder. That means if you are guilty, you are dangerous. So I'm going to set your bail at $100,000. Right? I'm not going to set your bail low. I'm going to set it high so that if you get out, you need to really, really work to get out. Now, understand this. When somebody sets bail, you do not have to come up with 100% of it. You have to come up with 10% of it, which is far more reasonable, because most people don't have $100,000 lying around, or anything bigger than that. But even at 10%, most people don't have $10,000 lying around that they can put up for bail. Now, bail is just collateral, right? So let's say you did have $10,000, you put it up, they hold on to it until you come to trial. And when you go to trial, when you show up, you get your money back. But if you fail to show up, which is what we call a failure to appear, often abbreviated as an FTA, you forfeit that money. So it's essentially collateral to get you show up to show up to trial. Now, this is very controversial because of economic disparity, right? Many people do not have the funds to do this. And people who are in the lower economic classes may not even have the funds to, if let's say they set bail at $1,000 and you have to come up with 10% of that. Well, many people who are very poor can't come up with $100 to make bail, which means they are detained. So if you are denied bail or if you can't afford to make bail, you are detained. You are held in a jail cell until your trial. This is how they ensure that you will show up. We simply do not let you go home, and we transfer you from the jail cell to the courtroom. Okay, it's a way of making sure you show up. But remember, our speedy trial, our Sixth Amendment right, only guarantees that gray area, that guarantee. We're looking at could be anywhere from 6 to 10 to 12 to 13 months before you make it to trial. And if you are denied bail or if you are put in pretrial detention, you are losing your freedom for an extended period of time. You don't live in your house. You don't get to see your family. You don't get to go to work, which means you can't pay your bills. You might lose your house. You might lose your car, right? Your family might suffer. They don't have your income. And let's say you are one of the lucky few who gets through to the trial and you are, acquitted. By that time, you've probably lost your job because most employers won't hold it for you for that long. They need somebody to show up. So there's a lot of controversy behind cash bail system, economic disparities, and the deprivation of liberty that happens during pretrial detention. One of the solutions to that is what we call release on your own recognizance. For short, people refer to it as ROR. And basically what they will do in that instance is say, okay, if you have a job in the local area, if you have a family, if you have a house, or let's say you have a lease on an apartment, you have ties to the local community, right? So you can't come up with the money for bail, but we feel that it's highly unlikely that you're going to flee because you are so tied to the local area. So we're going to release you on your own recognizance, which is basically saying you can go home, but here's your court date. We expect you to show up. If you don't, we're going to release a bench warrant and come looking for you. And if we find you, we're going to arrest you and you're going to prison for failure to appear. Okay, so there's a lot of controversy with bail, pretrial detention, discrimination on the basis of socioeconomic status, the damage that pretrial detention can cause, especially if you think about it in terms of what if you are wrongfully accused and you can't post bail, you've lost your job for maybe 10 months, maybe a year, you might have lost your housing, you might have lost your car, you got your day in court, you were acquitted, yay, but the rest of your life fell apart, right? So there's a lot of controversy around pretrial detention, bail, etc. Okay, there are two options. You can plea bargain, or you can go to court. What most people are very fascinated to find out about is that something like 96% of all cases are plea bargains, right? And that's a huge number of cases. A very small percentage of cases ever see the inside of a courtroom. Remember, we are told we are guaranteed by the Sixth Amendment to our day in court to be judged by a trial by a jury of our peers. Are we though? Are we? If 93 to 97% of all cases never make it to a court, do we really have that Sixth Amendment right? Or is it just in writing? Now, the flip side of this is we have to have plea bargaining because even with plea bargaining, the courts are so overcrowded, it takes a very long time for everybody to move through and get processed to get cases to come to the point of completion. If everybody stopped plea bargaining and everybody decided to go to court, it would take years and years and years and years before anybody's case would be heard, which certainly would violate your Sixth Amendment, not to mention would largely just collapse our court system. So plea bargaining is important. It's not pleasant, right? I'm sure if you ask any victim, they would prefer that, their case not be plea bargained out. But it's a way to keep the system moving, right? And the plea bargain is basically the prosecutor will say, hey, if you save the state the time, the money, the resources of having to try you in court, if you just plead guilty now and you save us all that time and money, I'm going to give you a lower sentence. It's a deal. It's a bargain, right? Now, plea bargaining can be very controversial as well. Right? If you are the accused person and you're staring at 25 years if you go to court and you lose and the prosecutor says, hey, I'll tell you what, if you just plead guilty, I'll give you 14 years and with good behavior, you might be out in 10. And you're like, but wait a minute, I'm innocent. I'm not going to prison. I don't want to go to prison at all. I'm going to fight this out. But what if you lose? Remember, juries are very emotional, right? And the number of people that we have wrongfully incarcerated in the United States is much higher than anybody would ever comfortably like to think that it is. So there tends to be an argument for a level of coercive or coercion with plea bargaining, right? That you don't get your day in court because even if you are innocent, you still have an incentive to play it safe. Because what if you lose, right? And innocent people have lost. Okay. So once you enter the court system, for the small percentage that do, it's adversarial in nature, meaning it is the prosecutor against the defense attorney. The defense attorney is representing you, and they battle it out. There's nothing polite about it. There's nothing friendly or gentle about it. It is a fight. It's a fight to see who can win. Okay, so it's an adversarial perspective. Or process. The judge is what I like to call the referee. Right. The judge is a former attorney who has had many years before they become judges. They've had many years as an attorney. So they know the process. They know the law very well. And they look at the prosecutor and they look at the defense attorney and say, hey, there are rules here and I'm here to enforce them. And if either one of you break the rules, I'm going to stop the proceedings and there's going to be an objection, which I'm going to support, or there's going to be, a hung jury, or you have to, he's basically, or she is basically there to referee and make sure everybody's following the law. The prosecutor has an exceptional amount of discretion. I want you to understand that. The prosecutor has perhaps the most power in the entire system because the prosecutor can take somebody who's been arrested by law enforcement and say, you know what, I'm not going to try the case. Right. And that's it. That's where it dies. No one can overrule or negate a prosecutor who exercises that discretion. A prosecutor also has complete discretion over whether or not they are willing to offer a plea bargain or whether or not they're willing to go all the way to a trial. Now, the interesting thing about the plea bargain, this is very rare. Only a prosecutor can offer it. You must, if you are going to take it, you must sign your guilt on paper. It gets presented to the judge. It is highly unlikely, but possible, that the judge can look at that and say, nope, I don't agree. I don't agree. You signed your guilt right here, and I'm not going to offer you the plea deal. I'm going to negate the plea deal, and you're going to do the full term because you just signed your guilt on this paper. It's very, very rare. It has to be very, very rare, right? If that were very common, no one would plea bargain. The whole system would collapse. In fact, it's so rare, most people don't even know that the judge can do that, right? Most people have no idea. A very famous case of that is an instance with Roman Polanski, who was a very famous Hollywood director who had, sexually assaulted a 12-year-old girl under the influence of narcotics that he provided to her. The plea bargain that was offered to him was, hey, we think there's something wrong. We want you to get help. We don't necessarily want to put you in jail for 20 years. If you agree to get help and go into therapy for a year or something, and plead guilty, this is where we'll go. And he says, okay. And he signed his guilt and he went before the judge. And the judge said, no, sir, no. You said you're guilty. So we agree on that. But I'm negating the plea bargain and you're going to serve your full sentence. At which point, with his money and wealth, he absconded. He got into a plane. He left the United States, went to another country where there is no extradition, which is where he still lives today. So it's very, very rare, but it can happen. I want you to understand that a conviction equals guilt under the eyes of the law, but an acquittal does not equal guilt, innocence. An acquittal means there wasn't enough information to convict. So here in the United States, we don't have any sort of outcome that says this person's innocent, go home, wipe the slate clean. No, an acquittal just means the state didn't have enough evidence to convict. It could very well mean that the individual is innocent, or it could mean they're guilty and the state just didn't have enough evidence to convict them. So that's something that's unique about us as well. I want you to know that in a criminal court, there is a standard of evidence that we call reasonable doubt. You've probably all heard of that from television, but most people don't know, what is reasonable doubt, right? If you had to put numbers to it, how much doubt are you allowed to have before the doubt gets too big and you have to acquit, right? You're allowed to have a little bit of doubt and still convict, but that doubt has got to be really, really small, right? And if you had to put numbers to it just to give you a conception, you're allowed to have about maybe 3% of doubt and convict. 3% of your mind could say, I'm pretty sure 3% that this guy might be innocent, but 97% looks like he's guilty, so I'm convicting, and that's okay because that's a reasonable doubt. But anytime it exceeds that 3%, you have reasonable doubt, and they are required to acquit. Okay, I will see you guys in our next chapter.